morning, good afternoon, good evening, depending on where you're at. Once again, we've got the East covered. We've got Buffalo, New York. We've got David Luzon, who's with Barclay Damon. And of course, we've got our producer, Mike, from the center of the universe, Toronto. And I'm still in Maui, lucky me. And before I get into introducing David and finding a little bit more about the firm he works with and what he does and the questions we have planned for him, David and I had a chance to have lunch in Mama's Fish House. Mama's Fish House. I've been eating too many chocolate almonds. It is the season. And David flew over from Honolulu, and I picked him up at the Kahului Airport, and I gave him the tour of the island, and then we went to Mama's Fish House, had lunch, and we had a great day. So, David, I appreciate you making that trip over, and welcome to the Snowbirds Expat Radio Podcast.
Gerry, it was such a pleasure to sit down and break bread with you on Maui, especially at Mama's Fish House. It was incredible. And I really appreciate the invitation to do the podcast with you.
Well, all I remember about that meal was I kept my lunch light because Tammy Jocelyn is always looking after me when it comes to desserts. So I know the script. I was able to have the chocolate mousse, which was bigger than the meal itself.
I'll know the secret next time.
Yes. Okay. So, David, tell me a little bit more about Barclay Damon.
Sure.
Yeah. Tell us more about it and exactly what you do, and we'll jump into some questions.
Sure. So I'm a partner at a law firm called Barclay Damon. We are a large Northeast U.S. regional firm. We have about 300 attorneys and 200 staff, so we're about 500 strong. Offices in New York City, Albany, Syracuse, Rochester, Buffalo, Washington, D.C., Boston, Massachusetts, New Haven, Connecticut, and Toronto, Ontario. I have to give you my little disclaimer in that we do have a Toronto, Ontario office. We don't practice Canadian law. We team with our Canadian professionals like yourself and like Canadian attorneys to make sure that client solutions work on both sides of the border.
Okay, interesting. Well, we're gonna, you gave me 10 great questions, and once again, I'm excited. We talked about this podcast on the two previous podcasts we had with our guests, and we've always been very loaded towards expats moving up to Canada here. Now, this podcast is for snowbirds. This podcast is going to be for snowbirds that own property in the States and spend all their time down south in either it may be Maui, may it be in Florida, may it be the Carolinas or the Arizonas of the world. But I'm going to jump ahead to question number 10 because this is the one that really comes across all the time. And really what it is that you're hearing about these snowbirds that go down for 6 months, and we keep on telling them you need a power of attorney in the state where your southern references, your snowbird nest is. You need a power of attorney for that state. So, David, let's jump into that question and tell us why we need to have a POA.
Thanks, Gerry. Yeah, great question. And, POA, and I'm going to include healthcare proxy also. So really, it has nothing to do with tax, right? And that's what we focus so much on. But these are incredibly important documents that anybody spending any substantial amount of time in a warm state or cold state, whatever they want to be in, should have. Let me tell you the horror story. And I described this to you, Gerry, when we were together. And very briefly, there was a couple out of Ontario, owned a home in Florida. They went back and forth for many, many years. Unfortunately, when they were in Florida, he had a stroke, but he did not die. They both went back to Canada, to Toronto, and they were never going back to their Florida property. She wanted to sell the property. She had a valid Canadian power of attorney for her husband that her estate planning attorney in Canada had prepared, but Florida rejected it. No state in the U.S. is obligated to honor documents executed outside of the United States. And so this poor woman had to get a guardianship over her own husband in Florida in order to sell the property. Thousands and thousands and thousands of dollars and lots of time and heartache and big court proceeding. So really, your Snowbirds should have a valid state power of attorney and state healthcare proxy in any state that they own property and spend any amount of time in. They should probably leave those documents at that property. There's no sense in carrying them back and forth. Leave the Canadian documents in Canada and the U.S. documents in the U.S. And if you ever need them, you'll have access to them very quickly.
Now, you said that no state is obligated to act on a power of attorney. That could be British Columbia, Ontario, but do you find that some states will
so inside the U.S., we have the full faith and credit clause here. So documents validly executed in one state are honored by the other state, but that doesn't apply to documents executed outside the country. I don't know. I haven't surveyed every state to see if they would accept a foreign executed document, but we know Florida didn't. And why take the chance? There are documents that may cost a few $100s to prepare, maybe more, but not an exorbitant amount.
Now, you're saying with your vast network of all these lawyers that you work with throughout the United States, if someone actually from this show was able to contact you, you'd be able to point them in the right direction. If you couldn't do that POA for them, you could actually point in the right direction.
Absolutely. In Arizona, California, Texas, many of the Sunshine States. And if I don't have a connection there already, I'll find somebody that's really good at what they do.
Well, this podcast has quite the reach, so I'm sure that every estate planning lawyer will be listening to this show. So here's the so let's go right to the top of the list. You provided me with some great questions. Okay, so here we are. If I own a real property in the U.S., will my estate have to pay U.S. state tax?
And so for Canadian citizens who are not citizens of the U.S. or resident in the U.S. Who own property, like most of your Snowbirds, in most cases, the answer to that is going to be no, because under the treaty between Canada and the U.S., the tax treaty, it allows a person in that situation to have the same estate tax exemption that a U.S. citizen would have this year, $12,920,000. But just a little asterisk on that, that's coming down in 2026 to maybe 6 to 7 million. However, the catch there is that on death, the estate has to file a U.S. estate tax return in order to use the treaty exemption. Otherwise, the decedent's estate would owe federal estate tax on any amount of value in the U.S. So if the property is worth $1 million, the exemption is actually only $60,000, $60,000. It's very small. So in order to get rid of the estate tax liability, the estate has to file a 706NA, that's a U.S. estate tax return for non-resident non-citizens, and ask the IRS to apply the treaty exemption and eliminate the tax.
Okay, so every time we ask these questions, we know there's going to be case studies or things that we've worked on together that we have to deal with. But at the end of the day, you're going to be able to help these Canadian Snowbirds put together a solid estate plan, and at the same time, you're going to be the attorney lawyer that's going to basically do a lot of this work on their behalf when that terrible time comes.
Yes, absolutely. And on the planning side, so it's kind of split up between planning and administration. If we end up with having Canadian citizens, one of them dies, they own a property in the U.S., we can help them file that 706NA and get out of the tax, reduce it, eliminate it. On the planning side, we can work with clients that want to transform that real property into a non-U.S. situs asset, so the 706NA would never be needed. So that's by transferring the property into a trust, a partnership, a corporation. And then when the person passes away, if they own that entity, they can pass that on to other people. There's no asset in the U.S. It's like magic in a way, but it's legal and ethical.
Okay. Just to remind everybody that, one of the features we're working on with our app, and David is going to be one of the first presentations, we're going to do a webinar. And David sent over his his presentation about 2 months ago, and I've had a chance to go through it. This is very, very complicated stuff for us snowbirds that look at life being very trying to keep things as simple as possible. So we're going to basically be doing a presentation, I'm sure, over the next 8 weeks, where we'll have on the app, there will be a pop-up feature. We'll be saying, here's when we have David. We're going to be doing this presentation. Through Zoom, there's going to be limited to 500 seats, so you do want to act quickly. And David will be putting on a presentation on truly the presentation that was sent to us, and he can go into the details. During that presentation, you can raise your hand, and I will ask the questions on your behalf to David. Just like today, there's so many questions that we have. I'm going to get into some of the more complicated stuff because we have these two loving countries, Canada, United States. There's a lot of times where an American will marry a Canadian. And does that really complicate their estate now that we've got this American person and this Canadian person? Is it more complicated?
The biggest complication is if somebody passes away without having done any planning. It doesn't overly complicate it if we, do the proper wills with the proper provisions, or make the proper entities to own property in the U.S. if they have it. So it doesn't need to overly complicate it. It just kind of increases the need to do some good planning.
I had a conversation with one of the younger advisors in our office the other day, and this young advisor comes from a family that's done quite well. And I said, you got to present to the clients that you are a beneficiary, and you should really know all the ins and outs of how that generation wealth is going to come down to you. And we started getting on the subject of, why don't people plan? Is estate planning the most intimidating? We got retirement planning, we got financial planning, but estate planning, is it so intimidating?
I think people perceive it as incredibly complex. Maybe they perceive it as being very expensive, maybe not worth the investment, but compared to the complicated problems in administration it causes without a plan, it is the best bargain around. And there's two groups of people. There's people like you, Gerry, that get things done. You think of something, you have a vision, you go after it, you get it finished up. And then there's the other group of people that don't want to think about the issue. Perfectly great people. We've got a lot of entrepreneurs in that situation with multiple millions of dollars. They're out there busting it every day, earning money, but they don't want to think about death. They don't want to, go through with the planning, or they might start and stop. So that's a hard question to answer. Sorry.
So it really doesn't come down to, a lot of times we think that, I grew up in a very small town on Vancouver Island, which is an island off the coast of Vancouver. You've got these people that are just hardworking blue collar people. Mm-hmm. And then you've got people in Vancouver. My second life, when I moved to Vancouver in the early 80s, I'm dealing with these lawyers and accountants and very intelligent. Well, hopefully the lawyers and accountants are doing their planning, but let's just say there's a lot of entrepreneurial professional people. But I find that there's just as many people on the island that grew up in a blue culture environment and a white collar environment. And it's the same thing. Like, both people procrastinate, both groups of people procrastinate.
Agreed. And, we get so many people that procrastinate, and then, they end up in the situation where somebody's died or somebody's heading toward death soon. And what can we do now? And it's never a great position to be in, as you know. You don't want to be in that 11th hour situation because it limits the options.
And we're going to save a lot of these really tough questions when we do the presentation through the presentation you provided for us and the webinar. So the questions I really have. So what is the process when a person comes to you and we get people excited and they know that they've been procrastinating, they listen to this podcast and they come to you? What's the first thing that you want from these people? Or how do you engage? Sure. And how do you connect with these people?
I'll tell you my process. I generally would schedule a video conference like this to get to know the people a little bit, to determine whether I can help them, and if so, how. But let's say that we've determined that, right? They want to do some planning. the first thing I do is send out a structured questionnaire. So that would tell me their assets, the status of their assets, the amounts, what's titled in the one spouse's name, what's titled in the other spouse's name, what might be joint. And I need all that information to determine, the U.S. estate tax consequences and how to plan for them. And so my process has been to get the questionnaire, do a complete analysis, and then do a memorandum to the clients explaining basically the U.S. State tax issues that I've identified in their planning, what the consequences are of not doing any planning and the projected estate tax that they might owe, and then giving them the options for planning that I see as real options. I'm not going to give them something that is far-flung and overblown, but the real options that I see for them, and then having a follow-up discussion with them and their advisor. I'm happy to welcome the advisor, the attorney, the financial advisor, both if the clients want them involved, in a discussion about which way they might want to go. And it's always been my opinion, my job as an attorney is to give people enough information to make an informed decision. It's not to push them toward one option or another. So I would then consult with them about whether or not they wanted to proceed, and if so, which option they'd like to choose, and then work on the implementation of that option.
So if you use myself and my wife, Melissa, as an example, we just had an estate plan that's being done in Canada. Mm-hmm. And it involves testamentary trust for the grandkids and for our one and only daughter, Chelsea. So I would imagine that you would have to work with that estate planning lawyer in Canada as well.
Absolutely. And many estate planning attorneys in Canada have worked on cross-border matters. And yes, I would take that instrument, hopefully before you guys executed it, and work with that Canadian estate planning attorney to make sure that it's going to work for your U.S. assets.
Now, if I remember, and like I say, we've just gone through this, they didn't really go into too much detail of our U.S. assets. And the company, we formed this company to qualify for a E2 visa down here, up here, whatever you want to call it, in Maui. But there wasn't really a big discussion around those U.S. entities.
Right. And there probably should have been some discussion about them, certainly. It's one of the great things about my working at a larger firm is that we have immigration counsel right here in the firm. And, I can bounce that question off of them as far as the specifics of, what happens with the E2 visa, et cetera. But yeah, there should have been some collaboration about how that's going to roll, right, when the time comes.
Okay, so we're gonna spend the next few minutes on ownerships of these Canadians. They, in this case, it's going to be both the husband and wife are Canadian citizens, and they move down to Arizona, and they buy a property. Now, what is the best way for those people to? Because what I find is people, for the first time, and we've talked about this in previous podcasts, they buy a home in an area they love. And they've got such separate lives nowadays if both of them are professionals, and they buy a home in a happy place. And for the first time in their life, they agree on something and they move quickly. They buy the home without really any thought in how that home should be purchased or how that home should be owned.
Yeah.
So what kind of advice do you give people that are in that situation so they don't make the mistake of not properly owning that real estate?
Sure. Let's start out with the fact that how the home is titled has nothing to do with tax at all. So if a couple owns it jointly, on the first death, it's going to pass by operation of law to the survivor, but that has nothing to do with U.S. estate tax that might be due. They're completely separate systems. But my advice to them, if I can catch them before they purchase it, is let's think about how we're going to own this. We can quickly get an answer, whether it should be purchased in a trust or a partnership or an LLC. If we miss them and they've purchased the property jointly, which the real estate agent, of course, is happy to do because it'll be a very quick sale and it'll be over. They get their commission. They're not worried about what's going to happen on the other side. There are solutions if they've already purchased the property, but there's one great solution that is eliminated altogether, unfortunately. So a wonderful solution for people in that situation would be to purchase it in a trust. If they haven't already purchased it, take title in the name of the trust. Unfortunately, if they've already purchased the property, transfer into a trust is estate taxable, period. Pretty much end of story if the people are going to use the property. And why wouldn't they be using it, right? So it eliminates a lot of options, unfortunately, or the best option.
Now, is that a big part of your field when people come to you? Do you take care of any of those snowbirds? They say, listen, if we have a presentation and we say, okay, we all agree we want to move to Maui. As Canadians, we want to buy properties. Do you get involved in that step? Or you
yes,
on the ownership? You take
certainly.
care of it. Okay.
Yeah.
Okay,
well, we don't practice in Maui. We can't close the sale of the property, but we can structure the ownership. We can write the trust, etc.
Okay. Because I think what happens is that what we find in Canada is a lot of individuals have a lot of their wealth trapped in these corporations, either a holding company, and that's where they want to own that U.S. asset. Is that quite common? If all that money is here and they buy a U.S. asset, is it
common for them to put it into a holding company in Canada?
No, what I'm saying is, yeah, that's the question. Because all the wealth is in these holding companies.
Yes, yes, it is. And so let's draw back. Let me correct something I said just a moment ago. If we're going to advise a Canadian couple on purchasing a property in the U.S., it's going to be purchased by a foreign trust for U.S. purposes. So it's going to be a Canadian trust drafted by the Canadian attorney, reviewed by us to make sure it works on both sides of the border. But if we're going to eliminate estate tax, the ownership has got to be in a foreign entity. So these holding companies that you're talking about, I'm presuming most of them are Canadian holding companies that own all the wealth. Yes, that is an effective way to eliminate estate tax in the U.S.
That's interesting because you and I are going to spend a lot more time on how do we get all this money out of the corporation. No, we're not trying to get the money out of the corporation. We're trying to get the title in the corporation. That's what we're trying to do, correct?
Yes, if it's a foreign corporation. Yes.
Exactly. Now,
and even U.S. corporations, right? Then, many times we'll transfer the shares of the U.S. corporation, so it's then owned by the foreign holding company. That's effective also.
Okay. Well, we'll make sure we have lots of diagrams when we're going over this webinar for the Snowbirds. Now, what are some of the other serious issues that you've come across that have just taken forever, where these people have made terrible errors with a lack of planning? What have you come across for these?
Yeah, thanks. So I'll tell you about two things if we have the time. The first is on an administration. I was contacted by a woman out of Toronto. She and her sister were the only children. Their mother recently passed away. Their father had already predeceased. A mother owned $1 million property in Florida. Their estate planning attorney in Canada said, "Oh, don't worry about the U.S. asset until we're done with the Canadian administration." That was a really, really bad piece of advice. The U.S. has a time limit to file that 706NA. It's got to be filed within 9 months of death unless you request a 6-month extension before the 9 months expires. They called me. It was well after the 9 months. It wasn't quite after the extension period, but they didn't have the extension period. So that left them in a situation of filing late and asking the IRS to exercise its discretion about whether or not to allow them to access the benefit under the treaty. So if the IRS says no, they're going to owe 40% of the $1 million to the U.S. government. If it says yes, they'll owe 0. but they've also incurred our fees in getting everything together on an expedited basis and, trying to get everything filed, which we did. But we'll probably wait a year before we hear anything on that. So if there's a U.S. asset, it's a long way of saying, if there's any U.S. assets, they should contact a cross-border person, accountant, attorney, soon after the death to find out if there are time limits and what needs to be done so they don't run afoul of that.
Now you used 0 and 40. I mean, I think a win
400,
would be
0 and 400.
Yeah, but you said 40. Yeah, 40%. So it would be 400,000.
Yeah.
Is there any hope that there's a little bit of discretion where they could say meet in the middle, or is it so black and white that it's 0 or?
I think it's going to be all or nothing, because it's going to be, if they're entitled to, if they exercise the discretion and allow the treaty credit, it'll be 0. If they disallow it, it'll be the full amount plus penalties and interest. I don't know how much motivation there is for the IRS to deny, right, the late filing. 400,000 is a pretty good motivation, I suppose, but I don't know what they're going to do. And why would you want to be in that position? That's the whole point, right? Let's do some planning. Let's get some good information as soon as possible, so you're not asking the IRS to exercise its discretion in your favor.
Now, you have to believe that because of the demographics we're dealing with here, older people that 75, 80 that own these properties, and they've got your younger kids. Are these older people so intimidated, or are they just saying, you know what, I'll let the kids worry about the estate problems?
I think they're letting the kids worry about the estate problems, and they're unaware that there are some real problems. I had a call just before this podcast from a Canadian accountant. And he's really sharp. He does a lot of cross-border work and preparation. They have a client. Older clients owned jointly a property in Florida in their own names. He died 3 years ago. She died 6 months ago. They were supposed to file a 706NA after his death. And they'll have to file another one now after her death. They're going to have to file 2. The issue there is that no buyer, when whoever goes to sell the property, is going to buy that property because there's a federal estate tax lien against it that went against it when the husband died over 3 years ago. They're going to have to do the same thing these 2 ladies I just described are going to have done. They're going to have to ask the IRS to exercise its discretion in filing late for the husband's estate to release that estate tax lien. Then they're going to have to file for the mother's estate to release that one.
We made when I was talking to this younger advisor in our office, I said, when you put on these presentations, it's almost mandatory that the parents have to make sure that the kids attend this presentation, this webinar that we have going, because the parents are not going to be able to grasp enough to be able to explain to the kids what they're trying to do. And of course,
Right.
The kids always want to have control over things and say, no, I've got a good attorney in Vancouver. Don't worry about it. We're well looked after. But that's not going to solve any problems by having just a Canadian attorney. You need someone like David, who is a cross-border expert in this field. So, David, now that we've scared everybody, including myself, what's the last words of wisdom that you can share with myself and the audience, all these snowbirds, to tell them how serious this is if no planning is being done?
So there's a couple things I would say. One is just general life stuff, right? Get the information. Getting the information is not engaging in all kinds of planning. Get the information you need to make an informed decision, right? Find out if there's a big problem, if there's a small problem, and what the potential options are. And then I'd say, it's probably not as bad as you may think, or could be worse. Sorry, that was really lousy of me to say, but it's hard to say until you have the information. You just won't know if you have a problem or how serious it is. And the other issue that I did want to bring up today, because I know you focus a lot on the day count and income tax, and that's really, really super important, but it has nothing to do with what we're talking about, which is estate, gift, and generation skipping transfer tax, the U.S. transfer tax system, right? Separate from the income tax system, and has different rules. You can avoid U.S. income tax, but if you own something in the U.S., you are automatically subject to U.S. estate tax and gift tax. So it doesn't matter if you spend 3 days here, you're still going to be subject to the estate tax.
One of the biggest things that I took away from our lunch and the opportunity to have David fly over to Kahului from Honolulu is that when you meet David, he's very personable. I look for these things that are important myself. That's the way I've always portrayed myself, is that I live in a very complex world of cross-border issues. But the biggest thing, I think, is that it's easy to take to David. It's easy for you to get your point across. And you are a very trusting person when you first meet yourself. So I think that's important for our profession and your profession. So, David, I look forward to our webinar, which I promise will be the first one, because this is serious stuff. I see a lot of older people in Maui that own these properties, and I've traveled throughout Scottsdale and Florida, and it's a common theme out there that I don't think people are properly set up. So this is going to be one of our, I'm not one to make New Year's resolutions, but I'm going to tell you that this is our commitment for one of our first in 2024, is to have David present very, very complex, and I hope people take advantage of reaching out to David. So David, on that note, I always tell people the world is small, be kind to all. Thank you for your time today, and we enjoy our relationship of working amongst our shared clients.
Thank you so much, Gerry. I really appreciate the opportunity, and it's great to see you again. And I hope sometime in the not too distant future, it will be in person. You can come to Buffalo, and we'll have buffalo wings instead of Mama's Fish House, but it'll be no comparison, but it would be great to see you.
Well, buffalo wings sound a lot cheaper than Mama's Fish House, so I'm all in favor of that, that's for sure. Okay, David, thanks again, and I appreciate your time.
All right, take care. Okay. Happy holidays to you and all. Have a great day.
You as well. Take care.